Hearing the appeal of a state mandate and giving the development company LTD against Junior Sammy Contractors LTD.
Yes, Mr. Rector-Davis.
My lady, I appear on behalf of Appellant EMBD, leading the learned friends Mr. Kangaroo and Ms. Jones. The respondent, Junior Sammy Contractors Limited, is represented by my learned friends Mr. David Thomas, Ramesh Mark, and Robert Strand. Lord, the appeal is with the leave of the Court of Appeal from the decision of that court in the Republic of Trinidad and Tobago, made on the 20th of July 2022. The order is at tab 4 of the key document. The appeal arises out of a sum said to be owing approximately 82.8 million Trinidadian dollars under 7 interim payment certificates, or IPCs, in respect of residential infrastructure works that Junior Sammy carried out for EMBD at a site known as the Corona Savannah Residential Development Phase B. Junior Sammy was the second contractor instructed, the first being a company called H. Lewis. The work was the construction of a road together with related works, including the construction of water and waste distribution system.
If it assists you, you can take it. We have read the SFI and the parties' cases and the judgments below.
Well, Lord, that's very helpful. I was simply about to mention that the factual and chronological background is set out in the agreed statement at paragraphs 3 to 27, and I won't trouble to take the board to it. So the board would have seen that summary judgment was granted by Mrs. Justice Dean Armourer on the 13th of January 2020, and she also dismissed EMBD's application for specific disclosure. She gave both oral and written reasons. The oral reasons are at tab 10, and the written reasons, which came 2 months later, are at tab 9.
We don't have tabs, so if you're wishing to refer to a document, if you give us the electronic page number, all our documents are in electronic form.
Well, I'm sorry, I assumed the board had the key documents.
We've got the key documents, yes.
Well,
as long as you're referring to key documents,
yes,
that is fine.
Yes.
Everything else will have to be by electronic page
I understand that, my lord. Well, that's one of the difficulties, but when I refer to tabs, I mean... You mean key documents, pardon.
Thank you.
My lords, there was controversy over the extent to which the first instance judge had adequately considered and dealt with the arguments of the EMBD. That controversy is now of no moment, but it's perhaps unfortunate that the Court of Appeal didn't deal with it. The grant of summary judgment and the refusal of specific disclosure were appealed to the Court of Appeal. A judgment was handed down on the 20th of July. Both appeals were dismissed, and the board will have already have seen that the judgment is at tab 6 of the key documents bundle, and the order at tab 5. There were 6 issues before the Court of Appeal, and they're set out at paragraph 33 of the statements and facts of this, which is behind tab 1, and it's page 4438. And I can just take the board through them so as to bring us to where we are today. The first one, which is 33A, the dismissal of the defence based on absolute assignment. That is live before the board today. Second, the first instance judge had held that the IPCs were not open to challenge. The Court of Appeal said that they were by way of a plea of fraud or abatement. However, the court said that there was insufficient in the defence to say that abatement or fraud was adequately pleaded to raise a defence with a realistic prospect of success. It was also said that EMBD's allegations are not raised timorously. The respondent has now abandoned that ground But overall, that issue is before the board today. And then if we turn over...
And do you accept that if fraud has not been adequately pleaded or that there's no sufficient basis for the plea, then apart from the assignment issue, the appeal would fail?
No.
What other issue is there?
No, my Lord, I don't. My Lord, what we say is that we pleaded the best we could, which were grounds for suspicion, and that gives rise to a triable defence.
All right, but is there any other issue apart from that one and the assignment issue that could allow you to succeed on this appeal?
Yes, specific disclosure.
Well, that's part and parcel, isn't it? Of whether
Indeed, my Lord, but those are the issues which
Yeah.
are before the board today.
So you basically say, we say what we've already said is enough, but if it isn't, then grant a specific disclosure and then we'll be able to plead more.
So if I can just deal firstly...
Why don't you exhibit the interim report of your independent quantity surveying expert?
I'm sorry, my Lord.
Why did you not exhibit the interim report of your independent quantity surveyor?
Well, it wasn't thought appropriate to exhibit...
Why?
To attach it to a pleading.
Why? No, to resisting the Order 14 application.
Can I just discuss with my junior? Why didn't we do it?
Presumably because it didn't help your case.
My Lord. Sorry. Yeah. My Lord, it was before the stage of disclosure and we were told...
Well, so what?
Oh, my Lord, my Lord, that's the answer to my Lord's question. It was before...
Have you identified a single person or a single witness that supports your case in the affidavits that have gone in the Order 14 application?
Not directly, my Lord, no.
Or
It's done in the affidavits on statement and belief.
are the sources and grounds of the information and belief identified?
No, my Lord.
Why not?
It was what we pleaded was the grounds for suspicion. And
It looks as though someone's just sat down with a copy of the bill of quantities for the previous contract and compared what was certified and identified a few discrepancies and thought that was good enough to plead fraud. Or not quite to plead fraud, but to threaten a plea of fraud.
No, my Lord. My Lord, that, with respect, is not fair. It oversimplifies the pleading, which sets out 4 areas where there was cause for concern, a ground for suspicion.
And what's the explanation why the engineer certified the certificates?
These are causes of concern and grounds of suspicion 4 years after the event.
Yes, my Lord.
And we're now 4 years further on. Yes. Well, have you interviewed a single witness before you make an allegation of potential fraud? Has a single witness been interviewed? For instance, your clients had personnel actually on site. Have they been interviewed?
Was Mr. Baxter interviewed first? Lord, there was a problem, I'm told, with witness availability. They'd either left or were tied up in the cartel proceedings.
You need to keep your voice up.
Lord, my lady, I'm so sorry. There was a problem with witness availability. They'd either left or they were tied up in other proceedings.
Well, they couldn't be found over a period of 8 years. 4 years, anyway. 4 years.
4 years. 4 years since then, my Lord.
Okay. There we are. Sorry.
Can I take you to the test for or the rules on summary judgment? They're common ground, but they're set out in paragraph 17 behind tab 2.
Yeah, that's very helpful.
Set out paragraph 17 to 19. No realistic prospect of success.
It's essentially the same as in this jurisdiction.
It is, my Lord. It is. Well, if I just before I move on, may I just mention that, Lord, what we need to see are the documents. We've asked for the documents, and if we were provided with them, we could perhaps have done a greater analysis, a better analysis than we've been able to do.
Well, you start fishing for the documents years later, though. That's the problem.
Well,
With no, as far as we can tell so far, proper basis for asking for any more information.
my Lord, fishing is not a fair verb. We start asking for the documents. I accept, perhaps later than we should have done. But if we'd been provided with the documents which we'd asked, we might have been able to make a better stab at actually pleading abatement or fraud.
But the context of this case is that you would delayed payment for years. And now, then when the contractor starts finally threatening you with proceedings, you start putting it off further by asking for documents.
Well, I don't accept that presentation of the case.
Why can't you get the documents from VCAB? Why can't you get the documents from VCAB?
They won't give them.
Well, why didn't you sue them?
Oh, yes, we might have done.
But why didn't you?
You say they won't give them. It's asserted by the respondents that under the contract, the engineer is your agent. Is that a correct characterisation of the engineer's position?
No, it's not. We don't accept that.
You don't accept it. Thank you.
What, you don't accept that they're your agent now, or for the purpose of the documents, or generally?
Generally. They were the engineer on the project. They exercised their own independent discretion.
That's not the same as being your agent, not being...
My lady, I appreciate that, but we don't accept that they were our agent for the purposes of the documents.
What reason do they give for not giving you the documents that they were provided with by Sammy?
Well, we don't know that they were provided with documents.
Well, have they told you that they weren't provided with them?
There's a paragraph in a witness statement put in by Junior Sammy which says they didn't provide them with documents, but beyond that I cannot say.
I see.
Okay.
So if I can come to the assignment case, and this is paragraphs 83 to 111 of our case. EMBD's argument is that by an absolute assignment made on the 16th of February 2016, Junior Sammy assigned 77.6 plus of the claim of 82.8 plus to Answer Merchant Bank Limited. And we say that that is so on the proper construction of the documents. And if it is an absolute assignment, the effect of Section 23, subsection 7 of the Supreme Court of Judicature Act would be that Answer, not Junior Sammy, would have the right to all legal and other remedies for the debt. And, my Lord, it's dealt with by the Court of Appeal at tab 6 of the key documents, paragraphs 10 to 31. And, my Lord, if we can find section 23.7 set out in full at page 1235 of the electronic bundle, paragraph 23. It's also, for the board's note, in the fuller bundle at 4532, but it reads, any absolute assignment by writing under the hand of the assignor, not purporting to be way of charge only, of any debt or other legal thing in action, of which express notice in writing has been given to the debtor, trustee, or other person from whom the assignor would have been entitled to receive or claim the debt or thing in action, shall and be deemed to have been effectual in law, subject to all equities which would have been entitled to priority over the right of this assignee if this act had not passed, to pass and transfer the legal right to the debt or thing in action from the date of the notice, and all legal and other remedies for the same, and the power to give good discharge for the same. I don't think I need read the rest of it. So the issue is whether the assignment was expressed in absolute terms.
Well, there are two issues, aren't there? There's one whether the assignment was expressed in absolute terms. The other is whether the assignment covered both the debt and the right to exercise legal remedies and power to give good discharge.
Yes.
Yes.
That's right.
Because I understand the respondent's case to be that they're not arguing that it was a charge, a security. The debt was assigned, but there was reserved to the assignor the right and, in terms of contract duty, to effect remedies under the contract against the employer and give discharge to the debt.
Yes.
That I think is the case you have to meet.
Yes, I'll come to that, my lord. May I deal first with the language of the assignment? We'll look at law, if we may, in a little while. But according to a case called Bexhill and Raskell, the question is the construction of the relevant instrument taken as a whole. And if I can just take the board to certain passages in and around the instrument. The first one is the notice of assignment, which is EB, Electronic Bundle 3255.
Okay.
And that is the notice of assignment, dated 16th of February. We, Junior Sammy, of the address, give you notice that we have sold and assigned absolutely with full title guarantee to Answer Bank all our rights, titles, benefits and interests whatsoever, present and future, whether proprietary, contractual or otherwise, under or arising out of the debtor sum of 77 million odd, the assigned sum due and owing by EMBD to Junior Sammy, under or in respect of the above contract, which debt is constituted or evidenced by the following invoices, and the invoices sued upon are listed, and the total is 77,658,928.91. And it says over the page, we hereby authorise and instruct you to pay to the assignee, whose receipt shall be a full and sufficient discharge, all monies whatsoever now at any time hereafter due or owing under or by virtue of the assigned debt. So that in that notice, it's referred to as an absolute assignment. And then, my lord, if we come on to the assignment itself, which is EB 3253, assignment of receivables made the 6th of February between Junior Sammy and Answer Merchant Bank, entered into a factoring agreement whereby the seller has agreed to assign and sell to the purchaser, and the purchaser has agreed to purchase the receivables. Now, this assignment witnesses, pursuant to consideration of and subject to the terms of the factoring agreement, the seller as beneficial owner hereby assigns absolutely and sells to the purchaser and so forth. And then again, the same invoices are listed, the same date, and they all come to the same total. And then, my lord, we have the factoring agreement, which is EB 3237, which is also dated the 16th of February. You see that from the first page. And then we go to the next page, which is 3238. Factoring agreement is made and entered into the 16th of February by Junior Sammy and Answer Bank. And there are some definitions which we'll come back to. Definition on the next page of EMBD receivables, definition facility amount, and there's notice of assignment. Means a notice of assignment in EMBD receivables sold and assigned to the purchaser under the agreement in the form set out in Schedule A. And if we go to 3252, you see the precedent for the notice of assignment, and that's exactly the one which was given by Junior Sammy to EMBD, and that's the one with the words assigned absolutely in the second line. I'll come to the significance of that in a moment. And then, my Lord, we have at 3240, clause 2.1, the seller as beneficial owner. Thank you. Yeah. The seller as beneficial owner hereby agrees to assign and sell to the purchaser, and the purchaser hereby agrees to purchase all the seller's right and interest in the full benefit of the receivables, free from encumbrances up to the facility amount, such sale and purchase to be effected in accordance with clause 2.2 and 3. And 2.3, if the purchaser wishes to accept the offer and then the machinery is set out, the purchaser shall pay to the seller the face amount of the relevant invoices, less the facility fee calculated for the term plus the buffer period, and payment shall constitute acceptance of the offer contained in the offer letter. As to the extent of the amount so paid as regards the receivable, and thereupon the full equitable and beneficial title to such receivables shall vest in the purchaser by way of absolute assignment. So, Lord, thus far, all the evidence in the instruments read as a whole suggests and refer to expressly absolute assignment. And then, my Lords, at 3241 is the requirement to give notice. Clause 2.4, the seller will give notice of each assignment in the form of the notice of assignment, and that's the document at 3252, which we've just looked at, and direct that payment shall be made direct to the purchaser. The invoice shall be marked indicating and so forth. All remittances, checks, bills, and other proceeds of sale sold to the purchaser shall be the property of the purchaser, and the seller authorises the purchaser to endorse its name on any or all checks whenever such endorsement is deemed to be necessary to effect collection. If any remittances are made directly to the seller shall hold the same in trust for the benefit of the purchaser and will immediately deliver to the purchaser the identical checks, documents, and so forth. So all is under the control of the bank. And then, my Lord, if we can just go then to the responsibilities of the seller, which begins at page 3243, clause 4.1. And 4.14 is the obligation on Junior Sammy to provide information, promptly to notify the purchaser of any request for extension of time to pay or request for credit or adjustment, or of any dispute or claim relating to any of the EMBD receivables or to services, and then at the foot of it, to keep purchaser informed of any actions taken by the seller for settlement, compromise, adjustment, enforcement, or other disposal of the same. And then clause 4.15, which is the clause which attracted the Court of Appeal, promptly at its own expense to take all such actions as are required under the EMBD contract to settle, compromise, adjust, or otherwise enforce or dispose of by litigation or otherwise any such dispute, controversy, or claim as referred to in clause 4.14, and to keep the purchaser informed of the actions taken by seller for settlement, compromise, adjustment, enforcement, or other disposal of same, provided, however, that seller shall obtain purchaser's written approval of any terms whereby seller is required to grant any allowance or credit to EMBD, or to adjust the amount of an invoice with respect to any EMBD receivables that are the subject of such dispute, controversy, or claim or payment. So, my Lord, it's not a question of a right to sue being retained. Subject to ANSWER's control, ANSWER put the burden of collection of the invoices on Junior Sammy. That's the way that we would suggest clause 4.14 and 4.15 are to be interpreted.
What's the difference between those two things?
Lord, my lady, the question is who has control over the monies?
Well, isn't the question who has the right to sue on the IPCs?
My lady, no, it's not in this respect.
Why?
I'll come to why that is. It's the question who has control over the monies.
What monies?
I'm sorry,
What money? Who has control over what money? Sorry, I haven't understood the
the
point
subject
you're
of the
making.
invoices.
The
The receivables, the subject of the invoices.
Right.
So you're saying 4.1.5 is written water because the Junior Sammy has an obligation to sue, but doesn't have the right to do so.
Yes.
Is that what you're saying?
Well, it's partly that, and partly, although it is sued, although it has the right to sue, it sues on behalf of Answer Bank and under the control of Answer Bank.
But so you say it has to sue in Answer's name then, or can it sue by virtue of this contract?
Well, the question is it an absolute assignment? And if it's an absolute assignment...
Excuse me, I'm interrupting, but the issue is whether they have standing to... I mean, your complaint is that they have no standing to bring this action, isn't it?
That's it. Because it's an absolute assignment. Read properly, it's an absolute assignment. And the effect of the section of the Supreme Court Act is to make the money recoverable only by answer, because that's the effect of the law.
So this clause is entirely misconceived then, 4.1.5?
No. So no, we don't suggest that.
Well, what is its effect?
The effect is to put the burden on Junior Sammy and take the burden of getting in the money away from Answer.
How do they do
By
that?
doing what?
By suing, under the control, which is exactly what happened.
But isn't that what they've done?
Well, no, because the claim is issued by Junior Sammy.
So are you saying the claim could only be issued in Answer's name
Because it's an absolute assignment.
by Junior Sammy? Is that what the contract's meant to mean? That Answer is allowing Junior Sammy to use its name to recover the debt?
Yes, maybe. Well, perhaps, but the point is, because it's an absolute...
With respect, you have to give me what is your interpretation of the clause. What does it mean?
Well, what it means is that Junior Sammy, as exactly what happened in Bexhill and Razak, Junior Sammy have the obligation to get in on behalf of Answer Bank the money. So Junior Sammy can sue, which of course is, I think, is the answer to my Lord's question. But because it's an absolute assignment, under the Supreme Court Act, the claim must be brought by Answer. So whilst
Sorry, you've just said Junior Sammy can sue, but under the Supreme Court Act, the claim must be brought by Answer. I don't understand that.
Well, what I'm coming round to, I think, is agreeing with my lady that it is a thing writ in water, because the effect of the Act of Parliament is that the claim must be brought by ANSA.
So Junior Sammy can't sue?
Yes.
Yes, well, what the Act of Parliament spoke about is that the absolute assignment was effectual to transfer the legal right to the debt, and it goes on, and all legal and other remedies. I think what is being said against you is that the remedy of getting in the debt under the factoring agreement was reserved to Junior Sammy. Otherwise, you are conceding that the clause is written water.
But the effect, the way I put it is that the effect of the Act is that the claim can only be brought by the bank because it's an absolute assignment.
It's an absolute assignment, but what happens if there is an absolute assignment of the debt but a reservation to Junior Sammy of the right to get the debt in and account to the assignee?
Well, the effect of the Act is that clause 4.15 doesn't have that effect, because the effect of the Act is that the claim can only be brought by the Act.
So if I wrote a contract, an assignment saying, I assign to you the debt, but I reserve to myself the right to get in the debt, and I undertake to you that I will do so, because it's an absolute assignment, the latter undertakings will be written water. Is that what you're saying?
Yes.
But what makes it an absolute assignment? Because it says it's an absolute assignment?
A, because it said it's an absolute assignment, and B, because the effect of the deed taken as a whole is that the receivables are under the control of ANSA.
Is an agreement under which the assignor retains the right to sue an absolute assignment within the meaning of the Supreme Court Act?
My Lord, can I answer that question this way? We say that the correct test is whether or not ANSA have the sole right to and control over the funds assigned. If it did, then the assignment was absolute, and only ANSA can bring proceedings.
Where do you get that test from?
My lady, it comes from the decision in Bexhill and Razak. Let me take you to it. It's electronic bundle, page 4596. Decision of the Court of Appeal in this country. And in the case, Bexhill were attempting to obtain possession of a commercial property given as...
Attempting to what? Sorry, I didn't hear.
Possession of a commercial property.
A commercial property?
Yeah. Given as security by Mr. Razak under a facility agreement. Bexhill had in turn drawn upon a facility agreement under a debenture with Barclays Bank and thereby funded the monies loaned to Mr. Razak. That debenture contained an assignment which was expressly described as absolute. And we can see that from paragraph 14 of the judgment, which is electronic bundle, page 4600. That debenture also included a clause under which Bexhill undertook to collect the receivables, and we see that at paragraph 19, which is EB 4601 and 2, By clause 7.12, Bexhill agreed to execute a legal assignment, etc., etc. Under clause 11.12, Bexhill undertook to ensure that all payments received under Bexhill facility agreements were paid directly to the collection account. By clause 11.13, Bexhill undertook to collect all other receivables in the ordinary course of trading as agent for Barclays, and immediately upon receipt pay directly all monies which it may receive in respect of the receivables into the collection account or such other account as Barclays may from time to time direct, but in the meantime hold them all in trust. Then if we come on to paragraph 27, page 4603, secondly, the judge dealt with defence of Mr. Razak. The defence was that Bexhill had no right to sue for possession of the property pursuant to the charge. The judge recited the submission of counsel that Bexhill had no title to sue for possession because any rights that Bexhill may have had to do had been assigned to Barclays. The judge recorded that counsel made 2 points. I don't think I need deal with that. And then if we can come to paragraph 37, I hope that I correctly represent counsel for Mr. Razak's position on the various possible outcomes. If there was an assignment by way of charge only, Bexhill would have title to sue for possession. On the other hand, if the right to sue Mr. Razak under the charge had been absolutely assigned to Barclays, then it would be necessary to consider whether Bexhill was entitled to pursue the claim. If Bexhill was entitled to pursue the claim as agent, then I think Bexhill could maintain the claim without the need. But if there had been an absolute assignment, Bexhill could not act as agent for Barclays in pursuing the claim, then Barclays had to be joined for the claim to be able to continue. I understood counsel for the other side to accept this analysis. And then at issue 2, we see at page 4608, and then paragraph 45, whether a particular instrument creates an absolute assignment or an assignment by way of charge only is a question of construction of the relevant instrument taken as a whole. That principle and the consequences of an assignment being absolute or by way of charge only were explained by Lord Justice Matthew in Hughes and Pump House. In that case, a builder sued to recover debts from his client under a building contract, but the defendant client asserted that the builder had assigned absolutely his right to sue for the debts to the builder's bank by virtue of the terms of an instrument between the builder and his bank. That assignment having been given in consideration, the bank agreeing to continue to provide the builder with finance. Lord Justice Matthew said, in every case of this kind, all the terms of the instruction must be considered.
The instrument.
I'm sorry, of the instrument. All the terms of the instrument must be considered, and whatever may be the phraseology adopted in some particular part of it, if on consideration of the whole instrument, it's clear that the intention was to give a charge only, then the action must be in the name of the assignor. While on the other hand, if it's clear from the instrument as a whole that the intention was to pass all the rights of the assignor in the debt or shows in action to the assignee, then the case will come within section 25 and the action must be brought in the name of the assignee. And then, my lady, I come finally to answer my lady's question. Lord Justice Matthew concluded that upon the correct construction of the instrument, the intention of the parties was to pass to the assignees complete control of all monies payable under the building contract, and that notice of assignment had been given, and so on and so forth. The same approach was adopted by Lord Justice Millett in the more recent case of Orion Finance. He emphasised the need to look at the substance of the parties' agreement as found in the language that they used in the document, in order to determine what the parties intended would be the legal effect of the document. In a subsequent case, Mr. Justice Reimer emphasised the need to prefer construction which makes a commercial sense. So, and then we go to paragraph 48. The starting point on the nature of the security granted to Barclays must be clause 3. On the face of it, Bexhill assigns and agrees to assign absolutely in favour of Barclays all of its rights, titles and interest, which is consistent with the assignment being absolute in the sense discussed above. Counsel concedes this much. So based on this clause alone, once the thing in action constituted by the right to sue on the charge came into existence, that would be the subject of an equitable assignment. Does that preliminary conclusion have to be modified in the light of the other provisions of this debenture and the BBFA, and by looking at the transaction as a whole to see the commercial sense of it? I can take you down, if I may, to paragraph 50. Whatever the position on the security in respect to the collection amount, it does not affect Council's principal argument, which is that the nature of the assignment granted by the clauses 3.1.1 and 3.2 is unaffected. I agree. The words of clause 3.1.1 and 3.1.2 concern receivables and each relevant contract. And then if I can just go on to paragraph 52, I have concluded that Mr. Council's submissions on this issue is correct. The wording on the face of clause 3.11 is clear. On the face of it, the clause assigns absolutely to Barclays all exceeding receivables, and when future receivables come into being, they will be subject to an absolute assignment in equity. None of the sub-clauses of 3.2 apply to the particular thing in action, comprised in the right to sue on the charge. Clause 5 confirms that the debenture is continuing security. And then we go over the page. Clause 11.13 is concerned only with the collection of receivables, not with the issue of whether any interest of them has been assigned absolutely to Barclays. It is common in the commercial world for A to act as agent for B to collect money or other property that belongs to B. And our submission is that those few sentences apply to this case. And then at 54, at the foot of the paragraph, as already noted, there is a difference between the assignee of a right under a contract and being the party who entered into the contract. It's understandable that Barclays wouldn't wish to take on any of the burdens of contracts with third parties, but only have the advantage of any benefits as assignee of rights. Further, as Council pointed out, if Bexley didn't contract as principal, it would have nothing to assign. And then what is described as being the deciding factor in this case is the obligation of Bexley in clause 3.3 of the BB debenture to give notice of assignment to other parties to relevant contracts, and in terms of that notice as set out in Schedule 2. The standard form letter is much more consistent with an absolute assignment rather than one by way of charge only. Further, the standard form letter stipulates expressly that all rights and remedies in connection with any agreement that is made between Bexley and its customers and all proceeds and claims arising therefrom are also assigned. The phrases in connection with and arising from are broad. And my Lord, that's exactly the same as in this case, because Appendix A to the assignment, to the factoring agreement, set out the precise form of words which Junior Sammy were required to give to EMBD. And my Lord, we've looked at the draft and the one that was absolutely given, and both refer to it being an absolute assignment. My learned friend, and my Lord, we say that authority is a very strong indication of the strength of our case, and the Court of Appeal fell into error in that it considered only clause 4.15 and did not refer to any of the other references.
In paragraph 40 of that, what the court held in Bexhill was that the right to sue was included in the definition of receivable, and that was also assigned.
Yes.
So the right of Bexhill to sue for possession fell, in the judge's view, within all rights and remedies relating to. But can you point to similar wording here which assigns, which defines the receivables as including the right to sue on the invoices.
Lady, the definition of EMBD receivables is found at page 3239. And it's the second entry down.
Yes.
Shall mean and include all present and future books, debts, accounts, contract rights, general intangibles, chattel papers, instruments, documents, and all forms of obligations owing or payable to a seller arising out of the provision of the service to EMBD under in respect of the EMBD contract, all proceeds thereof. So, my lady, yes.
But not claims for damages or other remedies for non-payment of the same.
All proceeds thereof, my lady.
Can I just take you back to page 4607 and what was common ground in this case? The first proposition was it an assignment by way of charge only? The second was if the right to sue Mr. Razak under the charge of being absolutely assigned to Barclays, then it would be necessary to consider whether Bexhill was entitled without joining Barclays to pursue the claim. And thirdly, if Bexhill was entitled to pursue the claim as agents for Barclays, then I think Mr. Leonard accepted that Bexhill could maintain the claim without the need to join Barclays. So, do I understand it correctly that the Court of Appeal decided that Bexhill was entitled to pursue the claim as agents for Barclays? And if so, then isn't Junior Sammy entitled to do exactly the same?
No, well, can I take you to paragraph 68 of the judgment? Which is
Yes.
4615. I would allow the appeal. I would propose that instead of paragraph 1 of the judge's order, there be suitable declarations to the effect that the charge and the right to sue Mr. Razak are the subject of an absolute assignment which operates in equity in favour of Barclays. Bexhill doesn't have the right as sole claimant to sue Mr. Razak on the charge, either on its own behalf or as agent for Barclays. C, if the claim against Mr. Razak is to pursue an application to join Barclays, the action must be made.
Well, wouldn't the appropriate thing to do here is for us to decide whether there is actually an arguable case, and if the action is to go forward, then ANSA can be joined as a co-claimant? Why is this a sort of knockout point in your favour rather than a matter that can be dealt with procedurally if it goes forward?
It's a knockout point to an application for summary judgment.
But not a knockout point at trial, is that right?
No. If it's right, it's a knockout.
Well, can you not join ANSA?
Well, it would be, of course, it would be open to them to join ANSA between now and trial. But at the moment, ANSA are not a party.
Right.
And I anticipate that there are limitation issues now.
Sorry, I didn't hear that.
I'm saying that I anticipate there would be limitation issues now.
Yes.
But the significance of it today is that we're facing an application for summary judgment. Now, my friend relies upon our DILA, which is 4533. Begins at 4533. And he relies upon our DILA to say in his case
that the primary indication is whether the assignee is intended to have the right to sue. And we see that at paragraph 98 to 102 of his case. But, my lord, that is not what Ardilla says. There were a number of features which were decisive in that case. And taking it as quickly as I can, if we go to paragraph 23 of the judgment, which is page 4539, it says the deed of assignment was not a well-drafted document. There are a number of terms which indicated that it was not intended to take effect as an absolute assignment, and which at the least cast doubt on an intention to make an absolute assignment of the right to bring a claim. Although clause 2.3 uses the words of illegal assignment, other provisions indicate an intention that the assignment was to take effect by way of a charge, the limited aggregate limit, that it was not an absolute assignment of the whole benefit of the SPA, and did not take effect so as to pass the right to bring proceedings. See clause 3.62. Clause 4.7, with its reference to Ardilla being obliged to pursue its rights, the effect of the assignment was that both Ardilla and the assignor and the assignee were acquired an equitable interest, whereas a matter of practice required to be joined as co-claimants so as to avoid the possibility of an argument that no issue estoppel would arise. So my friend overstates the case when he says that the ratio was that the right to sue is a primary indicator. That was not what was decided by Mr. Justice Simon in that case. We argue that the correct approach to construction is to give effect to all parts of the various agreements, and the authority for that is Chopra and Bindra, but I don't expect I need to take the board to that. There are 4 references to this instrument being an absolute assignment. We've looked at them, but they are page 3255, 3253, 3240, and 3252. The right to sue is not determinative. It's a factor to be considered. And read properly, 4.14 provides an obligation to provide information and see the last 2 lines, keep answer informed of steps for enforcement. And 4.15 requires Junior Sammy to obtain answer's consent before adjusting the invoices. Settlement of a claim requires answer's consent. Answer remains in control of the invoices. So, Lord, read properly, we say this is an absolute assignment. An alternative construction may be that clause 4.15 requires Sammy to take action under the EMBD contract in order to ascertain the value of the receivables, i.e. that certain sums are available. But if all these clauses can't be read together, then clause 4.15 should be treated as irrelevant to the construction of agreement as a whole. Because if the instrument is in truth an absolute assignment as we submit it is, the arrangements made between Junior Sammy and Answer as to the conduct of proceedings and claims can't order the legal rights between the parties, which are the subject of the Supreme Court Judicature Act. There is an additional point taken for the first time at paragraph 105 of my friend's case.
Sorry, was that your last point was that the arrangements between Sammy and Answer don't affect EMBD?
don't affect the status of the instrument if, in truth, read properly, it is an absolute assignment.
So one gets back to 4.1.5 being written water then? You say it's irrelevant?
It's irrelevant, my lord. That, my lord, is a better way of putting it.
So is the situation there then that if banks want to enter into these factoring arrangements with debtors, with people who have the benefit of invoices, if they want to have total control of the receivables as they come in, they cannot place on the seller of the receivables the burden of suing for the money if the debtor refuses to pay.
They should not. Cannot.
Well, there's a difference between imposing on them the actual obligation to bring the proceedings and what name they bring them in. I mean, you're saying, what, that they should have been brought in both names or in the name of the bank alone?
Both. Well, could have been brought in the name of the bank alone, but should have been brought in both names, because that would give effect to clause 4.15.
It would have what?
Give effect to clause 4.15. And then if I come on to the point raised for the first time in paragraph 105 of my friend's case, which is electronic bundle 4504, and they pick on the definition of the facility amount.
I'm sorry, the page number again?
4504, my lord.
Thank you.
And they pick on the definition of the facility amount in the factoring agreement being the total face amount of the EMBD receivables sold and assigned to the purchaser pursuant to this agreement up to the maximum amount of 40 million. And they build on that to say that would suggest that out of a total value of 77.6 million receivables covered by the agreement, ANSA was being assigned only $40 million. Now look, that's an odd submission, we say. Firstly, because we've looked at the assignment and the notice of assignment, and they make plain that in round terms, and forgive me rounding it up, 80 million was the subject of the assignment. You've seen the list of the 7 invoices, and the total is 77 point something million. The second aspect of why it's an odd point is in Mr. Ram Subir, who is the president of a related company to Junior Sammy, prepared an affidavit in opposition to what was said. And if we could look at that at page 1372 in the electronic bundle.
The facility amount is presumably the amount that was being advanced to Junior Sammy.
No, the way it seems to have worked is, and forgive me for using round terms, but Junior Sammy said we are owed 80 million. And the bank said, okay, on that basis, we'll lend you 40 million.
Yeah.
So in that sense, that was facility amount, yes.
So the fact that they've been lent 40 million doesn't prevent them suing for the full 77.
Let's be careful. What do you mean they lent them 40 million?
Your mind is quite right. They paid them.
They gave them 40 million.
Yes.
Yes, it's not a loan,
No.
because it's repaid
No,
by
It's the sale of a debt at a discount.
Yes, and that's exactly what it is. I was just going to show Mr. Ramsubia's affidavit because he uses similar language to that.
But I mean, whatever he thought was being done isn't something that we can look at to interpret the contract.
No.
But surely the better point for you is simply that defines the amount that was being advanced to Junior Sammy. It has nothing to do with the amount that, well, it does have something to do with it, but it's not the same amount as the one that the claim is for and which they're assigned the right to.
I'll move on, my lord.
But what then does it mean in when it says that the assignment is up to the maximum amount of 40 million Trinidad dollars?
I don't think it does say that. It defines the facility amount as being the maximum amount of $40 million, doesn't it?
The language is opaque. But
It means the facility amount can't be more than $40 million.
yes. Yes.
But that doesn't define the amount of the receivables
That's right.
sold and assigned.
And that's right.
But there's no other obligation on Sammy to pay back $40 million. They pay for the receipt of that money by selling the receivables.
Yes, to speak of a facility is perhaps a strange use of language because it's a sale.
Yes.
And what was assigned in clause 2.1 was the EMB receivables.
And does the bank have any comeback if against Junior Savvy if they don't recover the invoices? Because then there certainly would be an interest in Junior Sammy.
But I can't recall that there is any comeback in the assignment.
I thought there was
Well, recourse to seller in 2.5, what's that? How does that operate?
Yes. And I suppose if they simply don't do it, then they could be sued. Breach of contract.
in addition to the rights.
So they can reverse the assignment.
Yes.
They can reassign and pay back the
Reassign.
the seller shall have to refund to the purchaser. So to that extent, perhaps it can be described as a loan, or not as an outright payment.
What's the outworking of that? So that if Junior Sammy sues and fails, then they've got to repay the 40 million. Is that right?
I think so.
Yeah.
And reassign the
I
debt.
think that must be the effectual clause,
Yeah.
clause 2.5.
They might have a bit of an interest in being able to sue.
They might. They might, my lord. But
And it mightn't be an absolute assignment.
well, it doesn't have. I understand fully the drift of my lord's question, but it doesn't detract from the construction of the assignment taken as a whole.
While looking at remedies for the bank, there is also 3.1.2, the warranty, that the services have been received and accepted by EMDB without dispute or claim of any kind.
Yes.
Free of offset, deduction, counterclaim, etc.
But looking at it the other way, looking at clause 2.1, suppose Sammy sue and win and get $80 million, how much of that do they have to give to the bank?
They hold
None, I think.
They hold it all in trust for the bank.
All of it, you mean?
Yeah, they'd have to give,
Sorry, Sammy, all, yes.
yes,
From the bank, yeah.
in effect, your construction is that this is a sale of a debt, an alleged debt of about $80 million for $40 million.
That's exactly.
It's roughly a 50%
Yeah, exactly.
discount.
And that's what Mr. Ramsubir says as well.
Well, whatever you may have said.
So the words in 2.1 up to the facility amount, which we just saw is not more than $40 million, those must be just mistaken, or they don't mean what one might think they mean.
Well, if the receivables had been less than 40 million, I suppose that would have defined the facility amount, but they weren't, so it doesn't have any effect.
Okay, that's what Fox.
Where's the facility amount used in the text?
It's clause 2.1, which is 3240. Free from encumbrances up to the facility amount.
Well, then, why isn't there just then a limit? They've got a partial assignment of the of the 70 million.
Yeah.
That's the point they're making, that they've sold them all these, but insofar as they get more than $40 million back, it's not assigned for the extra bit. That's the point they're making in paragraph 105.
Yes.
So what's your answer to that?
Can I just go back one step? Because when looking at remedies between the bank and Junior Sammy, I should show you clause 7.1, which is 3246. Where there is a requirement on Junior Sammy to pay directly to ANSA if funds are not receivable due to its breach.
Sorry, explain that again, please.
Yes. If, for any reason, EMBD does not pay ANSA because of breach by Junior Sammy,
Yes.
Junior Sammy must reimburse the bank.
Yes, one would expect that.
Yeah.
Would that be consistent with the warranty?
Now, my lady asked a question. I'm afraid it's gone.
There's this oddity in 2.1 that it seems to say that the assignment of the receivables is only up to the value of the facility amount, and that is expressed in the definitions that you took us to $40 million. But we've seen that if you add up all the invoices in the schedule, they come to a lot more than that.
7%.
Right. So
It seems to be saying that they've only assigned 40 million worth of receivables.
Oh, my Lord.
And what they're saying in paragraph 105 is effectively we've only assigned them, they only get the benefit of $40 million. Who knows which of these invoices are going to be paid? But once some of them have been paid up to a value of $40 million, then the assignment goes no further than that. It's not quite clear how that works in the context of this contract, though.
My lady, it's not clear how it works. But what we do say is that it's plain that the 77 million was assigned, and the purchase price of that was 40 million.
Well, is it plain?
Well, where's it plain from?
The invoices attached to the assignment.
You have to read down clause 2.1 to get to that conclusion.
Well, the consideration isn't the facility amount, it's the purchase price.
And clause 5.1 defines the purchase price as being 52% of the face value of the invoices.
Yes.
Rightly or wrongly, I had construed this contract as a sale of the invoices for 52% of their face value.
With respect, I agree. That's what certainly that clause means, and that's why it's significant that the seven invoices attached to the notice of assignment and the assignment itself total 77 million.
But with a continuing interest in Junior Sammy in being able to defeat your client's defence of the claim. Because if it doesn't defeat the defence of the claim, it's going to have to repay a lot of money to the bank.
That is the effect of the instrument, yes.
Yeah.
Yes, because the bank can insist on the debts being bought back by
So it seems.
by Junior Sammy.
That is the way the bank would recover its investment.
Was there a similar clause in the Bexhill case?
I can't call it to mind, my lord, now.
Yeah. Okay.
Can I move on, my eye on the time, to the specific disclosure? Since the 12th of February 2019, EMBD has consistently asked for disclosure of details of Sammy's payment application, including substantiation and the measures of work undertaken. Also details of certification made by the engineers VICAB, including substantiation and measures of work undertaken, and all measures of work undertaken not included in applications and certificates. We needn't look at the correspondence, but it's in the electronic bundle, pages 3358 to 3378. The position is summarised in the defence, which is at EB 97, paragraph 2210. You see what I've just summarised.
You only get to specific disclosure, though, if you've got a sufficient basis for pleading fraud, don't you?
It's not quite as clear as that, my lord, although the Court of Appeal thought it was.
Well, why not?
Can I come?
You can't just not, hope to get disclosure, hoping you'll be able to plead fraud.
Can I come to that on the
Yeah.
notice? I'd just like to set out how we get there.
So the 2210 is a fair summary of what the correspondence
Yes, it is.
was addressing.
Yes.
Thank you.
And what we said at 2211 is we can't presently identify, without those documents, whether or not the works claimed are being carried out, and if so, in what amount, and what an accurate valuation would be.
Before we go into the details of this, my understanding was that the operation of the building contract or the contract was in effect brought to an end by the dismissal of the engineer and the non-appointment of a replacement engineer, and thereafter the sponsoring government department required an independent audit. That was from 2015.
That's the chronology, my lord.
Yes. Well, what on earth was the independent auditor doing after 2015 if access to this material was not available? What was going on?
I just don't know.
Has the audit produced anything, do we know?
It was said to produce something that had been sent to the ministry.
And it was said that a whole lot of questions were then going to be asked of VCAB. And Junior Sammy offered to meet with your clients, and they didn't take up the offer.
Well, Lord, that appears in the chronology, yes.
Yes. And one might like to have found out what the quantity surveyor was doing, producing a bill of quantities for the Junior Sammy contract, and get a statement from it. Might like to have actually interviewed some of your client's witnesses who were actually on the scene. Might like to have explained how the ministry decided to have independent audits, whether there was some specific worry or concern about this contract or other contracts or particular individuals and so on. Well, none of that's explained.
No, well, Lord, my instructions are that the audit was incomplete, but I have no further information.
Yeah, thank you. Thank you.
Lord, what's pleaded as paragraph 2213, 2214 on page 97 is that we would seek further disclosure, would seek voluntary disclosure, but then 2214 in the avoidance of doubt in the absence of documentation sought, unable fully and properly to interrogate the claimants entitled to payment. Says that the matters set out in the defence are necessarily preliminary in the light of the claimant's refusal and failure to provide the documentation to support his claim, and will be amended or amplified in due course. The application for specific disclosure we needn't go to is at EB 123, and it was made under Part 28, and we see Part 28 at 4523 of the electronic bundle. And if we could go to 28.5 on 4524, an order for specific disclosure is an order that a party must do one or more of the following things: disclose documents, carry out a search, disclose a document. And then we go with the page 28.6, when deciding whether to make an order for specific disclosure, the court must consider whether specific disclosure is necessary in order to dispose fairly of the claim or to save costs. Must have regard to the likely benefits of specific disclosure, the likely cost, and whether it satisfies the financial resources of the party likely to be sufficient to enable. It's never been suggested that it was burdensome for Junior Sammy to provide the documents, and I understand that EMBD offered to pay for it. Now, the Court of Appeal dealt with this issue, tab 6 of the bundle, paragraphs 116 to 123. A reference to Matthews and Malik, and then Atkin, which I'll come back to. And then at paragraph 120, what follows from this is that if specific disclosure could not be used to enable EMBD to determine if they could develop a claim of abatement, then disclosure would have no relevance to the claim, nor would it be necessary to fairly dispose of the claim. the pleaded facts first had to establish a viable claim of abatement before disclosure could aid the determination of the issue raised in the claim. And the judge determined that the caution given by Chief Justice Saunders, that's the paragraph above, was relevant to this case given the wide berth of documents sought, which suggested a fishing expedition of sorts. We agree with the judge in the decision to decline the EMBD's application for disclosure as a basis to determine whether it had a defence on any other issue. The application for disclosure could not legitimately aid EMBD to develop its pleaded case. And I'd just like to have a look, if I may, at two cases, remembering the words of 28.6, which is at 4525 of the bundle. When deciding whether to make an order for specific disclosure, the court must consider whether specific disclosure is necessary in order to dispose fairly of the claim. Now, we plead prima facie evidence of overclaiming. And we say that that can be proved or otherwise by sight of the documents. And that comes within the benefit, and that justifies the likely benefits of specific disclosure and the likely cost. Junior Sammy hasn't said that they don't have the documents. They said we have them, we said no, and they've not said it's onerous to provide them.
But to displace the certificates, don't you have to allege fraud?
Oh, I'm sorry.
To displace the certificates, as
Yes.
you have to allege fraud, and so the question is whether you've shown a sufficient basis to justify pursuing it further by way of specific disclosure.
Yes, exactly. Exactly. Now, look, I'll come to the authorities if I may. But firstly, if I can take you to the contract, and it's EB 77. I'm taking it from the pleading because it's easier. Paragraph 43. They are required to keep and provide the supporting documents as a matter of contract.
Which paragraph, sorry?
It's paragraph 14.3. It's on page 77. The contract itself is at page 2224.
Thank you.
Now, the Court of Appeal, if we look at paragraph 118, relied on a passage in Atkin, which is a summary of Abbas and Yusuf.
Is it the obligation in 14.3 to provide them to the engineer?
Yes. No, my lady, of course, not to provide it. I'm not suggesting to provide it to us, but they are under an obligation to provide the documents. So they must exist.
The documents must exist?
Yes. Now, the Court of Appeal relied upon that extract from Atkins, which itself relies upon a case called Abbas and Yusuf, which is our additional further authorities bundle at page 124. And Abbas and Yusuf was a libel case. And we see from paragraph 2 that no defence was served. And we see from paragraph 24 the CPR applicable in England and Wales. The court may make an order under this rule only where the documents of which disclosure is sought are likely to support the applicant or adversely affect the case of one or other of the parties to the proceedings, and disclosure is necessary. Paragraph 25, the general rule relating to the sequence in which a defendant may seek disclosure from the claimant and serve a defence of truth is that he must serve a defence of truth if he can, and then he will be entitled to disclosure which relates to the issues which he has pleaded. The defendant is not entitled to fish. And paragraph 30, at the end of the submissions, I inform the parties of my decision that this application must fail on the basis that it's premature. Until Mr. Shah has pleaded a defence, he has no case within the meaning of Rule 31.17.5a, which documents could support. That is the end of the matter. Well, my Lord, that is summarised as we see at paragraph 118 of the Court of Appeal's decision. But that is that Yusuf is an entirely different case to the case with which the board is dealing today. Because there was a defence, and I'm going to take the board to it, in which we set out the information which we have. And can I do it this way? Electronic bundle, page 70. Paragraph 7, we say the claimant has refused to provide documentation to support its claim when requested. Investigation has been hampered. Following service of this defence, the defendant will again seek voluntary disclosure. Thinks it right to bring this background to the attention of the court because it's probable that the defendant will seek to amend its defence to set out a full defence and counterclaim with leave once it's had an opportunity to consider the relevant documentation. And then specific disclosure.
And the thing is, if you'd asked for some documents in the course of the audit because you needed some help there, that might have been a different thing. But you wait, don't disclose the audit, which presumably was unhelpful to you, wait till you're sued, and then say, oh, well, we need documents in order to plead a defence. If your defence doesn't stand up on its own right, as at least a defence for which there's a reasonable basis, then you're not going to get the documents to try and find something else, are you?
Well, can I take you to what we were able to plead?
Yes.
And it's firstly, in respect of the road embankment, it's page 89. Electronic bundle, page 89. And the quantities applied for and certified in respect of that. And the gist of what we pleaded at paragraph 21.22 is that in March and June 2015...
Which page are we on now?
I'm sorry, my lady. Did I get the wrong...
What page are we on now?
I'm on page 90 of the electronic bundle.
90.
Between March and June 2015, claimant applied for 74 cubic metres of embankment. The engineer certified it in full. But H. Lewis had already been paid for just over 21 cubic metres.
But that's irrelevant. We're not concerned with their contract, and that's what seems misconceived about this pleading. We're concerned with what your clients quoted for, asked the contractors to quote for, Junior Sammy, and then compare that with what they did.
Well, can I...
Not what the previous contractors did or didn't do.
No, but, my Lord, it's relevant to what this contractor would have had to do.
No, it isn't, because what this contractor had to do was set out in a bill of quantities, which we've got.
Well,
and that included the full amount that it was paid for.
Well, I'm going to come to the underlying...
You think you can take away what Junior Sammy are meant to have done off that somehow? Sorry, H. Lewis are meant to have done. Yes, H. Lewis.
I understand H. Lewis. But look, I'm going to come to the inadequacies in the bills of quantities. It's a contractual point. But
the bill of quantities was prepared by your client. Yes. And they go out on the site and they estimate some, 72,000 cubic metres, and the engineer then actually measures 74,000. And you say, surely some mistake, it should only be 9,261 cubic metres. But it might be nice to have a witness to say, look, the amount of material that was removed couldn't conceivably be 74,000 cubic meters. Anybody could see that it was a fraction of that. Well, nobody. You had actual project engineers and people like that on site.
I understand that. I'm stuck with the pleading.
Yes, of course.
Yeah.
But what was...
You're putting repeatedly, you're putting the claimants to strict proof, but this is in the context where interim payment certificates have been issued. Yes. And there was a remedy under the contract when you came to the end of the contract to review the interim payment certificates through an engineer, either the one that was appointed or a replacement. And the appellants, no doubt on the instruction of their sponsoring department, haven't done this at all. They have ignored the contractual arrangements which were in place to enable them to challenge the interim payment certificates, and come along 4 years later with these allegations putting the claimants to proof. I mean, it's an astonishing set of circumstances.
Well, it isn't fair to say we're just putting you to proof.
Well,
We're saying we're putting you to proof in the context of the grave suspicions, which I'm just begun to take people through on the pleading.
And I do apologise. Which actual individual has these grave suspicions? The name, the qualifications of that individual? Who?
Julia's going to write it down.
Well, but I would like to have seen it on the affidavits and setting out some case of grave suspicions. It's easy enough for a high-level paper audit to be carried out. It's a totally different matter than to go on to allege fraud or to raise a suspicion of fraud.
And there's no explanation of why the engineer should have certified totally, vastly inaccurate quantities, unless there's an allegation of fraud against the engineer, which there isn't.
There is not.
With this embankment, what we're talking about is they're building a road, and then on either side of the road they build embankments to shield the road from view or to stop noise from the road.
Mounds on the side of the road.
Sorry?
Mounds on the side.
Mounds on either side of the road, right. But that's on your land, isn't it?
Yes.
Well, can't you go and measure how tall they are with a tape measure? I don't know how you do that. You must know how big the embankments are that are there. Why is it such a mystery? Why do you have to get from them how much mud they used when you've got the embankments on your land and you can measure them? That's what's puzzling me.
Well, I can't improve on the pleading case. Can I just take you through the pleading case?
yes.
What we deal with at 22.2 is the oddity that they applied, Junior Sammy applied for 74 cubic metres of embankment. The engineer certified it in full, but H. Lewis had already been paid for 21 odd cubic metres, and based on the claimant's own monthly statements, the total fill would only have been approximately 9,261 cubic metres, not the 74,000 odd claimed. So that's the first oddity. It's not only that H. Lewis had already done some, it's just it doesn't stack up with the monthly statements we've had. And then in respect of the earthworks, and this is paragraph 22.3, the gist of what we plead is that the figures claimed appear too high. The claim was for an area of 344,000 cubic metres to a depth of 300 metres.
Millimetres.
Millimetres, I'm so sorry. Yes, millimetres, sorry. But H. Lewis had already paid for doing the grubbing to a depth of 200 millimetres. And further, there is no evidence of site meetings or progress reports which support the huge number of men and machines that would have required to pay for work like that. And then if we go on to page 93...
Well, do those minutes actually record the numbers of personnel? Where are the documents which one can turn up to see the number of personnel on site?
They're not exhibited, my lord.
They're not. Why not?
They were not exhibited, my lord.
Yeah. Okay.
Well, the minutes in question, I think, were in Appendix 15 of your defence.
Yes, the site meetings that we had are indeed set at Appendix. There's a progress report at Appendix 16, and the minutes are at Appendix 15.
Yes.
And then at 93, there was the gist of this pleading is that the claim was for 15,550 cubic meters, yet the entire site had been cleared by H. Lewis. In any event, the total quantity of clearance required by the bills of quantity was only just over 2,000 cubic meters. And then the last one, which comes at page 95, is that the sums certified and paid were in identical amounts to the bills of quantity. Now, the bills of quantity were themselves remarkably round. And the
what?
Remarkably round.
Round.
Rounded, yes. Rounded figures.
Yes. We see that from the table at page 95. And the quantity applied for was exactly the same. Now, thus 22.8, we say real reason to believe that the works were over-certified and or incorrectly certified, and therefore may not be...
Just pausing before there, you're accepting in your pleadings that the bills of quantities were estimating that those works had to be carried out in the contract with Junior Sammy. That must be the case.
Yes, they were estimated.
Yes. And
Your point is it's odd that the estimate proved to be exactly correct to the nearest number. You know.
Yes, that's the point that's being made. But the point I was making, which I think Lord Leggett made earlier, was that the bills of quantities were prepared after the previous contract had been terminated, or certainly after the previous contractor had completed such works as it did.
Well, so what are you inviting us to infer then?
Questions?
Actually, nothing was done, but can't you see whether...
No, my lady. Not that nothing was done, but we can't be certain what was done. Because they're paid on application. So therefore the conclusion that is that there is real reason to believe that the works were over-certified and or incorrectly certified, and therefore may not be entitled to payment. And then 22.81, the Derry and Peat formulation is pleaded. 22.82, claimant's knowledge or recklessness making improper claims. and its supporters claim for declaration that they can't be relied upon and it must prove the work. So, my Lord, that is the pleaded defence. Now,
you don't seem to join issue with, well, for instance, the fact that the quantities predicted and the amounts claimed are sometimes coincide. The riposte from the respondents is that, well, for many items, e.g. manhole covers, ponds, trees to be removed, that's exactly what you'd expect. So to say that a large percentage are identical, and there's no comeback in relation to that, as far as I understand it. These points that are made by the respondent.
Well, they were only made in the case. They weren't made.
You would have thought that before making an allegation of this nature, one would have actually thought about that. I mean, these are experts engaged. Presumably, I don't know.
The points made in the case in response to these, which I'm going to deal with in the next heading, were not made before either the judge at first instance or the Court of Appeal. Right. The affidavit material which was put in before the judge at first instance focused on the inability to reopen IPCs and did not deal with the meat of the allegations. Yeah. But what we say is that we have here pleaded grounds for suspicion, and to borrow the language of the CPR, it is necessary to dispose fairly of the claim to give us the documents which we seek. Because there is a defence, and because we have gone further than in Abbas and Yousaf, which is inaccurately summarised, it is necessary to dispose fairly of the claim to allow us to have sight of the documents so we can interrogate them and either plead the case properly or plead the case better, setting out allegations which justify abatement or fraud, or, of course, pay the money claimed. But without that, it is impossible to do either. And all this could so easily have been resolved if they gave us the documents. The answer to my Lord's question, there were two experts. One was called John Palmer of Capita, a civil engineer, another called Giles Gurnham of a company called Quantity Surveyors called GB Squared.
What was the second name, sorry?
Charles Gurnham of GB Squared.
Thank you.
Well, they've changed then, because it was originally Skinner and Joseph Quantity Surveyors and Earth Investigation Systems Limited, whom your clients had retained.
I think they did.
And so there are new people we know nothing about.
I think that's right, isn't it? Yeah. It was a change.
Well, 3293 identifies those individuals.
These are the only experts who were retained.
Okay. These two were retained to advise on the dispute. The name that my Lord has just mentioned did a line audit. Yeah. The audit which was done earlier, which my Lord has already identified was not disclosed.
Yeah. So these two individuals haven't produced a report and have advised us at some date we don't know about.
I can get the date if it.
Yeah, that's okay.
Can I come on then to the...
Well, just looking at 3297, what it says there is that in a letter to the president of Junior Sammy, is that the appellants in this case have been liaising with VICAB Engineering in relation to questions raised by the independent auditors, and they say as soon as a final determination is made, we undertake to inform and update you on the same, and that was back in May 2017. That appears to be the position then. Do you know whether the appellants ever informed Junior Sammy of the outcome of the audit?
No, there is no evidence of that.
No.
Can I now just look at the extent to which, irrespective of the application for disclosure, the pleaded defence of over-certification or reckless over-claiming is sufficient to open up the interim payment certificates? The first instance judge held that they could not be opened up at all. The Court of Appeal accepted that she was wrong and they could be opened up. And without going to the paragraphs, it's paragraphs 58, 67 and 68 of the judgment. And that is because of the decision of this board in a case called NH International and National Insurance Property, and the relevant paragraphs are at page 5130 of the electronic bundle. On clause 2.5, seems to the board that paragraph 40, the structure of clause 2.5 is such that it applies to any claims which the employer wishes to raise. First, any payment under any clause of these conditions are words of very wide scope indeed. Secondly, the clause makes it clear that if the employer wishes to raise such a claim, it must do so promptly in a particularised form. That seems to follow from the linking of the engineer's role to the notice and particulars. Thirdly, the purpose of the final part of the clause is to emphasise that where the employer has failed to raise a claim, the back door of set-off or cross-claim is firmly shut. The reasoning of Lord Justice Hobhouse in Mello supports this conclusion. It also demonstrates that a provision such as clause 2.5 does not preclude the employer from raising an abatement argument. So the Court of Appeal accepted, based on this dicta by Lord Neuberger, that abatement is, at least in theory, arguable. A fortiori, we would say, the issue of fraud. The Court of Appeal said that fraud wasn't pleaded, and they're right, but the ingredients of it are pleaded.
You accept that now?
Yes, I've always accepted it, but the ingredients of it are pleaded.
But I don't want to go around in circles, but I think you've accepted already that clause 2.5 can't be operated in this case because the engineer has been removed and there's no replacement.
Well, whether or not clause 2.5 could be operated, it doesn't need to be operated because we're not arguing set-off or counterclaim. We're only arguing abatement, and that escapes the clause 2.5 prohibition. And the Court of Appeal also said that abatement was pleaded, but insufficiently. The Court of Appeal said two further points. We didn't raise the issues sufficiently timorously, and there is reference to estoppel.
My friend does not put any reliance upon the absence of raising these issues timorously, although he does give some support to the estoppel. We've looked at the paragraphs in the defence, and I don't propose to take you back through that. And I only wish to add that the defences were supported by affidavit evidence from the in-house attorney, Marissa Singh-Zorro, and that's paragraph 29, which we don't need to look at page 1392 of the bundle, and paragraphs 38 to 39 at page 1396 of the bundle.
1396.
1396, my lord.
Those are the affidavit.
Those are the affidavits, my lady.
Of lawyer. Of lawyers, yes.
Yes.
And the first page number, sorry, I missed it.
1392, paragraph 29.
Thank you very much indeed.
And the second was 1396, paragraphs 38 to 39. And they were...
Can you just clarify your case on fraud? You said the Court of Appeal held that fraud had not been pleaded, and we accept that, but then you said that the ingredients were pleaded. So are you accepting only that the word fraud didn't appear, but you are asserting that a claim of fraud was properly pleaded because the ingredients were pleaded, or do you accept that there was no pleading of fraud?
We pleaded that the consequences of what we suspected Junior Sammy had been doing would reopen everything under the doctrine that fraud unravels all. And therefore we pleaded the consequences, or the ingredients, the Derry-Peak ingredients of fraud.
So you are saying that the Court of Appeal was wrong to say that you had not adequately pleaded a claim of fraud?
Well, it depends what they meant.
You don't have to use the word fraud to adequately plead a claim of fraud.
No, they're right, we didn't use the word fraud. I mean, that is...
Well, that's...
But we pleaded the ingredients.
Ascertained, right. But
So you are making an allegation of fraud against Junior Sammy?
We make the allegation that there are grounds for concern. We need to see the document.
Well, that's different from making an allegation of fraud.
May I just complete my sentence, my lord?
Yeah.
We make the allegation that there are grounds of concern. We make the allegation that if we see the documents and that justifies the concern, then the consequences of fraud are that all is unravelled.
Yes, and the affidavit evidence, the only relevant passage, I think, is 1396, paragraph 39, and the key words are, in light of EMBD having reason to believe that the works were over-certified and or incorrectly certified, and therefore that Junior Sammy may not be entitled to payment. Junior Sammy is required to establish by evidence that the sum is due. Is that a basis for undermining the interim payment certificates?
Yes.
Saying what?
Interim payment certificates are not final and binding.
No, because there's a mechanism in the contract which the appellants have chosen not to operate, which could have determined whether those certificates were correct.
Or the remedy of abatement.
Well, you say that. Under 2.5, you not have to operate 2.5 in order to claim abatement.
My lord, no.
In order to make any deduction from an amount certified.
No, my lord. Paragraph 41 of Lord Newburger in NH International. It's page 5130.
Yes. Well, I'm wondering. I mean, these are things that are collateral to the certificate. You know, that the work wasn't poorly done, for example. But if even you're quarrelling with the measurements of a work, which are certified by the engineer.
What we would say is that supposing £100 of work is claimed, if the certificates don't show that that full £100 of work was done, then we abate that £100 claim down to, if necessary, down to zero. Obviously not lower than that, but down to zero, or whatever the value of the work was done. Part of our problem is that we didn't know the value of the potential abatement because we hadn't seen the documents. But nevertheless, all were aware that a proper plea of abatement was coming as soon as we could, and that was canvassed in our submissions well, at paragraph 58, page 251, and paragraph 61B and 62, page 253.
But irrespective of that, if there were fraud, then you'd have a claim that payment's been claimed for work that wasn't in fact done, and was dishonestly, and there was a dishonest claim. The question is whether there's any basis, proper basis, pleaded for making that allegation. And you seem quite rightly to be reluctant to say so, and putting it instead on grounds for concern, which is something different and doesn't amount to a basis for alleging fraud.
Well, which is why, my Lord, we don't allege fraud, but we do say that there is good reason to suspect.
There's good reason to suspect that they didn't do the work they claimed for, and if that, on sight of the documents, turns out to be true, then it may also be true that they knew that they were claiming for work they hadn't done. That's as far as you can go, really.
Yes. Yes. But this is of perhaps some importance, because having won on the issue of whether abatement arises in an IPC situation, we won on that issue, and the Court of Appeal decided that IPCs or accepted that IPCs are not final, and abatement is available as a remedy to establish what is the actual sum due. The effect of the Court of Appeal judgment is to limit the right to abate. Now, can I come to the pleading requirement in Trinidad and Tobago? And if we go firstly to page 4517, Rule 10.5.
Can I just mention, Mr. Acton Davis, you do need to keep an eye on the clock.
I am.
If you don't mind my reminding you.
No.
If I don't, I'm sure Mr. Thomas might.
No, I'll take it as quickly as I can. Lord, there have been a number of interventions.
Well, that's true, but that's par for the course.
I'm not complaining, but it's more by way of explanation, but certainly not justification.
Yes, 10.5.
Yeah. The defendant must include in his defence a statement of all the facts on which he relies to dispute, short as practicable, and then over the page at 5, subparagraph 5, in relation to any allegation in the claim form or statement of case, the defendant doesn't admit or deny it or put forward a different version of events, he must state each of his reasons for resisting the allegation. And my lord, that's what we did.
There's a slightly different issue on an Order 14 application. It's not just, there's my defence, be happy with that. You actually have to put in something called evidence.
Yes. 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 Can I just concentrate on the pleading issue for a moment, my lord, and then...
Yeah.
So, we did what we could. We listed the reasons for resisting the allegation, and I paraphrase, suspicious. And we pleaded suspicion of overclaiming. Now, there's a Trinidad case, Randy Amoroso against the Attorney General, where we see, and it begins at 5197, and at paragraph 10, it said that the claimant's case must be properly pleaded in his statement of in case and include all material facts of the claim as it provides the structure for defining the legal issues to be determined. Further, the statement of case ought to be sufficiently pleaded so the defendant is aware of the case he has to meet. And then in another case called MI5 Investigations, which is at page 4865, which was a strikeout case we see from paragraph 1 at 4866, and 4867, paragraph 6, rule 10.5, and the Court of Appeal set out the contents of 10.5 and says at 7, in respect of an allegation, the claim form must be admission or denial, and then it goes on. If I can just take it from the end of the paragraph, where the defendant doesn't admit or deny an allegation or put forward a different version of events, he must state his reasons for resisting the allegation. The reasons must be sufficiently cogent to justify the incurring of costs and expenditure of the court's resources in having the allegation proved. And what we say is that an analysis of the available information lead to the conclusion of suspicion that the claimant must have known, or at the very least been reckless as to the accuracy of its claim, although it's not yet possible to provide a full particularized case. That, on its face, is a type of reason that would justify the incurring of costs or expenditure of the court's resources. And there's another case in the Court of Appeal, which we called Ramnight, and perhaps I can do no more, which begins at page 5233, than to draw the board's attention, paragraphs 5, 7, 1, 7, 3, and 23, where there is reference to the difficulty of pleading detailed particulars in a case involving unlawful conspiracy, knowing and reckless overclaims. But because although that's not on all fours with this case, they share a reality about the amount of information which may be available, at least before disclosure. And in that cartel case, the Court of Appeal accepted that the necessarily skimpy pleadings, which relied upon inference, was sufficient to defeat a strikeout application. Some further assistance comes from an English case in the Chancery Division called Gulati, which is at page 4741, which is a telephone hacking case. And at paragraph 7, counsel submitted that a case shouldn't be allowed to go for trial because it's asserted some further evidence may turn up, and he relied upon a decision of Lord Justice Morbick. But as
Justice Mann said, Lord Justice Morbick was dealing with an argument that further facts might turn up which would affect the construction of a commercial document. He expressed the view that a submission that something might emerge should be treated with caution, not that it should be rejected out of hand. Paragraph 14 makes it clear that it's seeking to distinguish between real and fanciful prospects of success. That is the real distinction. He was not dealing with a familiar case in which claimant makes an ostensibly sustainable allegation, but acknowledges that the process of disclosure is necessary to make the case stronger or to have it investigated properly. It's a familiar state of affairs that a claimant is ultimately reliant on disclosure from the other side in order to bring his case home, particularly in cases where the nature of the wrong is such that the defendant's activities were covered. So if the case is good, the defendant is likely to have a substantial amount of material on its hands with no equivalent in the hands of the claimant. Unless the prospects of getting disclosure are fanciful, the claimant is generally entitled to maintain its case in those circumstances. And then there's a reference to Doncaster Pharmaceuticals. In my judgment, that case is reported as having said the court should also hesitate about making a final decision without a trial, where even though there is no obvious conflict of fact at the time of investigation, reasonable grounds exist for believing that a fuller investigation into the facts of the case would add to or alter the evidence available to a trial judge and so affect the outcome. And then at paragraph 9, these present cases, that's the telephone hacking cases, are capable of falling into the category of cases which require full investigation. And I rely upon the rest of that paragraph. So that we say is obviously not on all fours, but gives useful guidance to the board in this case. We have pleaded the best we can, and it would be wrong to stop us from going any further, simply because we don't yet have disclosure. There is one other issue which the Court of Appeal found against us, which was we didn't raise these matters sufficiently timorously, but it seems from paragraph 83 of my friend's case that has been abandoned. And there is also in the Court of Appeal judgment some suggestion that we are estopped because we didn't follow the dispute resolution process of a DRB leading to arbitration. That's paragraph 61 of the Court of Appeal judgment. Well, Junior Sammy started these proceedings. EMBD seek to defend itself, and we say that we're fully entitled to do so, bearing in mind what is now established and the provisional and interim nature of the IPCs. It's unclear what sort of estoppel is relied upon. No representation is identified, no reliance or detriment is mentioned. And the respondent's case doesn't assist because they say little about it. And as for the engineer binding EMBD, which is said at paragraph 61 of the judgment, that we don't understand. And again, the respondent's case is silent on this issue. My Lord, with my eye on the clock, can I just deal with one final matter? In their case, at paragraph 59, and this really is the longest part of that case. They deal with the succeeding paragraphs of why, up till 71, of why the concerns expressed in the pleading are misplaced. That has never been canvassed before. It was not the subject of any evidence at first instance or even in the Court of Appeal.
And in the Primeo Fund case, which this board will be familiar with, the board warned against behaviour such as that. I'm not going to waste time by taking you to it. The board will be, or at least two members of this board, will certainly be
I'm sorry, I can't hear anything that
well,
you're saying.
I'm not going to take the board to the decision in the Primeo case.
You say warned against behaviour such as this.
Yes, I mean, the point you're making is the discussion there of finality in litigation, yes. And you can't take legal arguments which were not raised in the courts below on appeal. That was really the warning that was being given.
There was that, but there is also reference to raising facts for the
use of fact, yes.
In the board. That's what I read.
Yes, do you want to just give us the reference to the paragraph numbers or whatever? So.
Yes, I have a feeling, although some of us were in Primeo, some of us weren't.
Yes, well, two were, I think.
Some of us bear the scars, what you said.
So are you saying that we must disregard their answer to your pleaded case?
Yes. And the references for my Lord Legate, AFA bundle, paragraphs 145 through until 151. And perhaps 155 for completeness, which are pages 43 to 47 of the AFA bundle. Can I just give one example of the dangers of such an approach, which my friend urges upon you? If we take, for example, the references in the bills of quantity, for example, if we look at, and it's behind tab 3 of the key documents bundle. If we look at paragraph 62.1, their answer depends upon the accuracy of the bill of quantities, and we see that 62.1 and 62.2, and we see it also in, well, those two will do as a start. But bills of quantity are by themselves approximate documents, and we see that from the contract in this case. Firstly, if we could have a look at EB page 2307, paragraph 6.4.
Well, that's accepted. The bill of quantities was 70 cubic metres and the amount claimed for was 74, but it's approximate, but they're simply making the point, and I don't see why they aren't entitled to make it, that your case, based on ignoring what the bill of quantities that you put in and estimated they were required to do, because you say one should deduct from what you said was required the amount which the previous contractors had been certified as carrying out, even though you knew that, what they'd done at the time when the bill of quantities was drawn up.
But to make that point, my lord, they rely upon the figures in the bill of quantity, and they are themselves approximate, so that they shouldn't be relied upon.
Yeah, they are, and they do.
But you're relying on them. I mean, you're relying on what was done, but you say you just ignore the estimate of what was expected to be done, do you? I mean, what's wrong with the point they're making, which is your argument proceeds on saying, oh, well, you couldn't really have done 70 because the previous contractors have done 21, to which they point out, well, you asked us to do 70, knowing what the previous contractors had done. It seems a pretty good response to me.
Well, can I focus on the last three lines of paragraph 62.2? A final measured total of 74 cubic metres against an expected need of 70,800 cubic metres is not evidence of fraud or wrongdoing.
Well, you agree with that, presumably?
Well, Lord, what I am saying is that the expected need is not a figure to be relied on.
By who?
No, it is simply an estimate.
That's really the point they're making. That if it turns out to be 74 and the bill of quantities specified 70.8, well, there's nothing surprising about that.
Yeah.
But your point, which is perfectly valid, is to say that the 70.8 is an estimate.
That's right.
Yes, but I'm not sure that gets you very far, because why would one make an estimate of 70.8 in the bill of quantities when H. Lewis had already carried out work, unless 70.8 was what was thought to be needed to be done?
Knowing what H. Lewis had done.
Can I perhaps help this way? It's important to bear in mind that the bills of quantities are not part of the specification. They are there for tender comparison. And if we look at the contract, for example, paragraph...
So they were asked to tender off the basis of having to do 70.8, and now you're complaining that they did 74, and that seems a fairly poor basis for complaint. I mean, you were telling them they would need to do 70, and they should estimate that in terms of what it was going to cost them and what they were going to bid. And now you're saying it's some evidence of prima facie fraud, that they charged for something pretty close to what they were asked to bid against.
But they rely upon the expected need of 7,800. And we say that 7,800 is not a reliable bottom line, because it's an estimate for the purposes of assessing tender.
Well, how do you get to the 7,800 then? What is that figure purporting to be?
I'm giving evidence, but a quantity surveyor looks at the site and assesses what he thinks is necessary.
Yes.
And to complain about fraud, you have to suggest that that figure was way off the mark. The figure that you yourselves put forward and invited them to conduct their tender against.
For the purpose only of comparing tenders. So all people who tender...
But the quantity surveyor who prepares the bill of quantities visits the site, has available to him the contract drawings, and prepares his bill.
Yes.
I mean, it's not some degree of inaccuracy, some estimate is necessary because you don't know the final amount of work that's going to be done. But that was a professional assessment at the time by your quantity surveyor.
But if we look at what is described as a final measured total of 74,000 cubic metres, we don't know whether that was measured, who measured it, because we haven't seen the documents.
Well, we know the engineer was satisfied that it had been done.
We know that he signed it off.
Well, indeed. That's evidence that he was satisfied it had been done. Unless you say he was acting...
But can I make absolutely certain I understand, because you've been very careful about not, frankly, alleging fraud against the respondents. And you've also been absolutely clear, as I understand it, not to allege fraud against VCAP. Right?
I'm sorry, I nod yes.
Sorry?
I nod yes, that doesn't come out on the transcript. Yeah.
And even further than that, you're not alleging a reasonable suspicion of fraud against them.
Yes.
Yeah, okay. And how on earth could they have certified 74,000 cubic metres where your defence suggests that it's only 9,000?
I cannot answer that question.
Yeah, okay.
Well, why do you say it was only 9,000 when your bill of quantities said you needed 70.8?
Because that would be an expert advice. Yes, the answer to that one is that was the expert advice which we received.
Right.
Can I just touch on two more points?
You're not able to say, well, we initially thought we wanted an embankment that was going to be...
And now we realise we got it disastrously wrong in the bill of quantities.
Now we decided we only wanted a tiny embankment, not a big embankment. So there's no variation of the contract.
I'm not able to say that.
No.
Just perhaps a few more points on this. 65(2), they say that given the passage of time, it's hardly surprising that some clearing and grubbing had to be redone. But fill, which is the other part of this, is an entirely different category. That is not likely to degrade and unlikely to be removed from site. So what they say in paragraph 65 is no answer to the fill.
You're saying that there's no likelihood that sand over a 4-year period will be washed away in Trinidad and Tobago?
Well, we're in the realm of speculation.
That's exactly the problem, isn't it, with your case?
Well, it's exactly the problem with this new point being raised at this stage. We're not in a position to answer adequately, other than by casting doubt, which I endeavour. And then the last point comes under paragraph 69. And this is the quantities of off-site disposal. We accept, of course, that item 27 covers disposal, but this item is really about excavation. You can't dispose of something unless you have excavated. And it is odd to read of a claim of removal and disposal of 15,515 cubic metres if only 2,140 was excavated. So these, as I have endeavoured to express, are the concerns we have, and the unfairness with being expected to deal with these new arguments of fact without any evidence in this board. I accept that our answers may or are be inadequate, but that is not our fault. It is not our fault that none of this was canvassed on affidavit at first instance. Could have been, should have been perhaps, and we could have dealt with it. So I would invite the board to deal with this appeal on the evidence available to the judge at first instance, and indeed the Court of Appeal. So, Lord, I've gone on perhaps 25 minutes more than I should have done, and I apologise. I thank the board for its patience.
Just wondering, would Junior Sammy have to reveal on contract bids in the future that they have been reasonably suspected of fraud in relation to this particular contract?
That would depend upon the terms of the tender document.
Yes. And some of these arguments that are now being made against the respondents, could they reasonably be anticipated by experts?
By experts?
Yes, retained before an allegation of reasonable suspicion of fraud is made.
Yes.
Yeah. Thank you.
Thank you very much, Mr. Action Davis. What we'll do is we'll adjourn for a short time in order to consider where we are and what we may need to ask Mr. Thomas to address us on. So if you don't mind remaining available, we'll adjourn and hopefully come back in about 5 minutes. So, Mr. Thomas, there are 2 points we would welcome your assistance on after the short adjournment. The first is the issue relating to the assignment. And in that regard, obviously it's a matter for you what you address us on, but we would welcome hearing you on the Bexhill case, and also on any relevant aspects there may be of the law of Trinidad and Tobago in relation to standing. The other point on which it would be helpful to have your submissions is the submission that we received from Mr. Acton Davis that the engineer acting under this construction contract was not the agent of the employer. Well, we'll adjourn and sit again at 2 o'clock. Sit again at 2 o'clock.